right, thank you very much for coming. As you read, and as I read, the San Francisco Chronicle reported today that there were, Jackson's here, but reported today that there are as many as 80 San Francisco police officers who have either prior convictions or evidence of misconduct that hasn't been disclosed to the defense. We don't know who the officers are yet, but we do know if this evidence is true, it is explosive. It'll have a tremendous impact on criminal trials and cases that we've handled involving these officers. The prosecution has an absolute duty to provide evidence of prior conviction and misconducts of all of its witnesses. This is a constitutional requirement under the Brady case. There's also a statutory requirement that evidence of prior convictions be turned over. So we have a situation here which is really unprecedented, because in each and every case, prosecutors routinely run record checks on witnesses. Usually at the beginning of trial, prosecutors are required to provide a rap sheet of any witnesses who will be called by the prosecution at trial. They also typically will run rap sheets of defense witnesses as well. So the fact that these officers suffered convictions and misconduct would create a situation where every case where one of these officers testified, and if there was a conviction in that case, it could be jeopardized. So we're talking about a situation which goes far beyond what we've seen already with Ms. Madden at the crime lab. As you recall, we recently learned that Ms. Madden had been convicted of a crime of moral turpitude, a domestic violence case in 2008. We were not provided this information, even though throughout 2008, 2009, and 2010, this information was requested specifically with respect to Ms. Madden. So what this means is that we have as many as 80 additional witnesses who may have misconduct records that were not disclosed. Ultimately, the district attorney has got to answer for this, because it is her office that has the duty to provide this information in court. Every day when we handle criminal cases, we must rely on the integrity of the district attorney's office to ensure that all the evidence that's required by law is provided to the defense. In many of these cases, the credibility of the police officer is key. Just to give you an example, I tried a case last week involving allegations that my client, the person I represented, assaulted a police officer. In that case, the critical issue presented to the jury was the credibility of the officers. And so if the officers have prior conviction or other misconduct evidence that has not been provided, it creates not only a serious problem, but shakes the entire foundation of our criminal justice system.
Do you see a number of people being let go who have already been convicted, and what do you think that number might be?
Yeah, I thought the headline in the Chronicle, no, I know, Jackson, you don't figure out what the headlines are, or you don't decide what the headlines are, was unfortunate, because it gives the public the misimpression that this is all about just letting criminals go. You know, this is a situation, again, we have certain rules when we do trials, and part of a fair trial means that you are provided all of the evidence that you need to properly defend a case. And as I said earlier, prosecutors routinely impeach witnesses, defense witnesses, with evidence of prior misconduct. In the case I recently tried, they impeached 2 of my witnesses using criminal convictions. And so for them to shield, essentially, police officers who are often their star witnesses in these cases is not only unexcusable, but unethical. And I have a hard time believing that 120 attorneys who work at the district attorney's office would not have run a criminal conviction check on police witnesses. This is either a systematic failure, which would suggest gross malfeasance, or unethical behavior, if they knew that these police witnesses had prior convictions and no action was taken. And again, I want to preface that, these comments by saying we don't know who the officers are yet. And so it would depend on whether these officers regularly testified in criminal trials, what the nature of the misconduct was, but this is certainly not something that was known to us. At the Public Defender's Office, we do not have access to criminal convictions of witnesses. That only comes from the District Attorney's Office, because the District Attorney's Office has access to the computer database, which contains information relating to these convictions.